one. Well, I have the unique challenge to be the last commenter in the last session, and having also landed from New York a few hours ago, so I'm slightly, that's what, you have coffee for, I guess. So, thanks. My comments will be divided into three parts. First, I would address some aspects of the theory of humanitarian intervention as punishment that Evan has critiqued. Second, I will say a few words about the fiduciary theory of intervention. And third, I will offer a defense of Evan's idea of deliberative engagement, but one which emanates from just war theory, not fiduciary per se. So, about intervention as punishment. So the theory is that states intervene to punish and therefore protect international law as a normative order. That's the Grotian view. The paper argues that intervention as punishment rests on natural law assumptions that are no longer accepted. So two distinctions should be made in this context. First, I think when we discuss what is accepted and what is not, we have to differentiate between primary norms and secondary norms. I think that nowadays there is very widely accepted notion about the primary norms that we're talking about, protection of civilians, etc., etc. What is not accepted is how you protect these norms in terms of institutions, in terms of who authorizes, etc., etc. And I think that we mentioned China before. I think even when China is nowadays portrayed as non-interventionist, when you see the discourse in Security Council, China always says, well, China has always tried to promote human rights and protection of civilians, etc., etc., but we don't think that the Security Council should be intervening in this situation. Second, I think a distinction should be made within the punitive discourse itself between theories of retribution and deterrence. I agree that retribution as an independent justification for intervention is something that rings as obsolete. But deterrence is something else. I don't think deterrence is based on natural law. Deterrence is based on instrumentalist justifications. And here we have a different argument. I think it's a very problematic justification for intervention because it's vague, it's easy to abuse, etc., etc. But I don't think it's based on obsolete natural law perceptions. I think this is something that has to be mentioned. And for instance, the quote by David Cameron that you cited here, I think he discusses punishment in terms of deterrence, not in terms of retribution. And I think this is something we have to look at. Regarding the fiduciary perception of intervention, so you mentioned this, so I only will mention this briefly, but the fiduciary exercise of fiduciary powers assumes that the beneficiary has the rights to grant, right? And this is a problem because arguments from collective self-defense have to make a very clear statement about the self-defense rights of individuals or groups within the state. And international law is not yet there. So any theory of fiduciary and humanitarian intervention has to be very clear about what we can call internal use ad bellum, or when does this right actually materialize. So this is also something that I think can be developed. About the Grotian theory, so one of the suggestions in the paper is to update the theory by recognizing a duty of deliberative engagement. And this emanates from the concept of fiduciary relations. Now, I fully agree, and I would like to offer a few comments. One is to look at Libya. You mentioned Libya as an example of where the Security Council has limited the discretion of the interveners. And this can support a fiduciary conception. But I think what's more interesting in the Libya case is that it actually supports your concept of deliberative engagement, because if you look at what happened there, actually, the Libyan delegation said, well, we don't represent the Libyan government anymore, we represent the Libyan people. And we want help. They said that in the council, and when you look at the protocol and you look at how states explain their votes, in this case, they actually referred to this plea for help. So this is a type of engagement with the opposition, and I think this supports your argument. And in any case, I would like to complement your reasoning by maybe defending the duty to engage with the opposition from a just war point of view. Now, just war criteria, as everybody, I assume most of the people here know, are not only ethical criteria for when engaging in war is just, but I think it's also, they remind us of modern criteria of reasonableness, and I think any exercise of fiduciary power should be measured in terms of its reasonableness. So this can also complement specifically the issue of fiduciary perception of intervention. So, of course, the criteria of just war, the well-known criteria are right authority, just cause, right intention, reasonable prospects, and proportionality. And I think when you apply these criteria to the question of deliberative engagement, you actually reveal that there is a duty emanating from just war theory to engage with affected individuals or groups. And this can affect, importantly, this can affect the legitimacy of action, even if not the legality per se, even when the Security Council fails to act. And I think this is an important point. So just for a brief exercise, let's assume four things. Let's assume we have a government that commits grave atrocities against civilian population. B, let's assume the existence, and these are all big assumptions. Let's assume that there is an opposition that generally seeks to protect the civilian population. C, let's assume that this opposition has formed a reasonably representative transitional entity, maybe Libya, not in Syria, as we know. And D, that this opposition has granted genuine consent to a party to intervene. So let's make these assumptions and look at just war theory and see that actually deliberative engagement kind of serves as an indication that the just war criteria exist when engagement or consent exists. So very briefly, when we can talk about this later, but regarding right authority, you can argue when deliberative engagement exists, you actually have a situation in which the affected individuals and then identify the person or entity that they want to assist them. And I think this creates some kind of moral proximity between the intervener and the affected party. And I think it lessens a paternalistic element of intervention and enhances autonomy and self-determination. This is all not unassailable in any way, but I think it's maybe a way to look at it. I think that just cause can also be augmented by consent of the opposition. I think it's reasonable that credible opposition groups would not grant consent to external forcible intervention unless it's really needed. And this is because of the potential harm to their credibility if they ask for intervention for no just reason. I mean, imagine that a major opposition is against intervention, a major opposition group is against intervention in a specific case. This seems intuitively to affect our perception of the justness of the cause of the intervention on a very basic level. So if this is so, we must also accept the reverse claim that consent of the opposition also affects our perception of the justness of the cause. Regarding right intention, I think it's obvious that genuine opposition consent to humanitarian intervention can maybe lessen our suspicion that the intervener is acting strictly for selfish reasons. Remember, we are assuming genuine consent here, which is a big assumption, but still. Reasonable prospects, also very obvious. If you have the cooperation of some forces within on the ground, obviously your prospects of success are higher. You don't have to fight everyone, but only certain elements. And when you look at Security Council practice, actually the Security Council usually seeks consent of at least one party, and I think it has to do a lot with the reasonable prospects that you have someone to cooperate with within the state. And a closely related effect of consent is on the question of proportionality in terms of just war theory. Again, for obvious reasons, if you have cooperation of internal elements, so obviously the scope of your operation can be narrower. You don't have to fight everyone. You can only attack or act against certain elements within the target state. So all in all, and I will finish here, I think the requirement of deliberative engagement is well grounded in just war theory, and it's very interesting to analyze how this intertwines or interacts with the issue of fiduciary humanitarian intervention. So that's it for me. I'd be happy to